Hello, viewers. Welcome to another episode of Immigration for All, presented by Nora Global and powered by Khulna Tech. For today's session, I'm your host, Orpa. You may already know that we have rebranded our popular Monday Live series under this new banner to better reflect our mission of providing comprehensive immigration insights. So, for today's session, our topic is the latest update on asylum in the US. Without any delay, let's welcome our guest speaker, Mr. Raju Mahajan, the principal attorney of Raju Law.
Hi, Orpa. Thank you very much for inviting me. I welcome all of our audience at this moment and down the line later in our different platforms.
Hello, Mr. Mahajan. Thank you so much for joining us. So, how are you doing?
I'm good. Thank you very much. How are you?
I am also very fine. So, before we dive into today's topic, I would like to remind that if you have any questions or comments, feel free to share them with us through the comment box or via email. Additionally, Mr. Mahajan will be taking live calls after this presentation. You can find the call in number displayed on the screen. So, Mr. Mahajan, you can please proceed with today's topic.
Thank you very much. I would like to start the presentation. We're waiting for the slide. Oh, what happened?
We might be encountering some technical difficulties.
Yeah. All right. If we cannot show the PowerPoint, that's okay. I can talk about asylum in general. So let me start talking, and at the same time, our technical team, please try to upload the PowerPoint. If you can, that's okay. If you cannot, that's okay too. So, dear audience, as you already know, our today's topic is asylum. Many people, they apply for asylum here in the United States. They're from different part of the world, and many people has many questions about asylum, especially if there is any significant change in their home country situation. Okay, we got the PowerPoint. All right. So as you already know, it's asylum. Can you please go to the second slide? All right. Thank you. So many people ask me question, what are the grounds to apply for asylum? So here are the grounds. It must be race, religion, nationality, membership in a particular social group, political opinion. So, and all these topics are very broad topic, very broad title, like race. Race is a very complex, very broad topic, but it must be related to race. At the same time, religion has like a different, big, like a broad idea of religion. So it can be anything related to religion. Nationality is also a very big topic. Membership in a particular social group, this is kind of catch-all situation. So if you are a member of any kind of particular social group, and if you have reasonable fear for your life or your immediate family member's life, you can file for asylum. And also political opinion, that's another big topic. However, many people, they contact me and they tell that they have problem with their family members based on ownership of the properties. So let's say you are 4 siblings, and you received some property from your parents, and now you have a very bad relationship with your siblings regarding the distribution of this property. You cannot file asylum based on that kind of situation. This is your personal matter. This is a family matter. American government is not going to help you resolve this issue, because it's not in any of these matters. At the same time, a lot of time people, so let me be very honest with you. A lot of time people try to show some reason that is not very serious, very severe, because they feel that if their asylum application is not approved, if they go back to their home country, they will not be subject to any persecution because of this asylum application. So you cannot just show a very simple reason and apply for asylum. That is not going to survive, because millions of people every year, they apply for asylum in the United States, and a lot of them, a significant number of them, their application get rejected. Unfortunately, there are some community leaders in the immigrant communities. They always encourage people to apply for asylum because it's easy to apply for asylum, and sometimes community members, they take some money in exchange for helping you apply for an asylum, and they heard from someone else that he or she applied for asylum and got approved very easily without any problem, blah blah blah. None of those are true. Please consider it seriously before applying for asylum, because this is a very serious application. A lot of time people call me and they talk in a way that asylum is like, oh, I don't have any option, I'm going to apply for asylum. You cannot do that. Asylum is a very serious application. You must have a reasonable fear for your life or your immediate family member's life based on these grounds. If you do not have those, if you apply for asylum, 99% chance your asylum application will not be approved. Even after 5 years, 6 years, 10 years, if your asylum application is not approved, what you're going to do? Are you going to stay in America without any status illegally? That's not a good life. I do not understand what kind of people advise others to apply for asylum without a valid ground. This is going to ruin your life. Not only your life, your family members, especially your young kids. A lot of family members, they apply for asylum with young kids without any valid ground. Not only you're ruining your own life, you're going to ruin your kids' life too. They will be stuck here in America without any papers, and that life is not a honorable life. It's not a happy life. So that's why, in this show, I would like to tell people that if you will really have a good ground, yes, please go ahead, apply for asylum. American government, if your case is approved, you're going to get green card. However, if you do not have a valid ground, please do not apply for asylum. That is not going to help you at all. That will make your life miserable when this asylum application get denied. So that was my clear message to all of you. Next slide, please. All right. So many people, since we already discussed about grounds, now let's talk about the steps. People also have a lot of wrong impression about the steps of asylum application. So the first one, so let me make it clear. So there's two different group of people. One who come to America with a valid visa. Let's say you're coming to America with a student visa or visit visa or any kind of business visa or any medical visa or anything. If you have a valid visa when you entered America and now you want to apply for asylum, you will go to the route that is called affirmative asylum. So first we're talking about the affirmative asylum, and then we're going to talk about defensive asylum. So those who come to America without any valid visa, like, let's say crossing the southern border or some other way, or you entered America with a valid visa, but your visa is expired. You do not have a valid visa at this moment. At that moment, if you want to apply for asylum, it would be a defensive asylum. So in the affirmative asylum application process, the first application is asylum application. So there's a form. You're going to fill up the form. You're going to submit all the information, all the supporting document, your picture and everything, and submit to USCIS. You can submit a digital copy online, or you can apply with a paper-based application. Depending on circumstance, USCIS prefers online application. We also prefer online application because it's fast and there's a less chance of mistake in the online application. Once you apply for application, you will receive a receipt notice. Please remember, receipt notice doesn't mean that your case is approved. All it means is USCIS received your file. Many people, they have a wrong impression that, my file has been accepted, meaning they approved my asylum application. No, your file has been accepted, meaning they just received the file. All right, after receipt notice, you will wait for 150 days. After 150 days, you will be eligible to apply for work authorization, meaning you'll be able to work legally here in America. In general, it takes 1 month. Sometimes it may take shorter, sometimes it may take longer to get the work permit. The short version of work permit is called EAD. Many people call it EAD card, which is also okay. Work authorization is okay, work permit is okay, anything. It's just a different name. Once you receive the work authorization, work permit, you can work in any field. There is no restriction, there is no limitation. You can work based on your skill, your ability, anything. After receiving work authorization, USCIS will call you for interview. Now, when they will call you interview, that's up in the air. Nobody knows. Sometime you may get called within 6 months. Sometime you may get called within 1 year. Sometime even 2, 3, 4, 5, 6, 10 years. I saw people, they have been waiting for interview for 6, 7 years. Now, there are some ways to expedite the process. I'm not going to talk about those today because that's not the topic of discussion. I think we have done another video on how to expedite your application. You can go to our YouTube channel, Facebook page, and you can find those videos or audio, and you can learn about that. So the steps after EAD card, biometric appointment, and EAD, sorry, immediately after the application, there's a biometric process. I had to forget to tell you about that. So once you receive the receipt notice, the immediate next step is biometric appointment. Government will capture your fingerprints. After that, you apply for EAD card. When you receive the EAD card, then government will call you for interview. So the affirmative application interview is a non-adversarial interview, meaning USCIS officer is not going to try to establish that your case is not good. All they're trying to do is they're trying to understand your situation. They will ask you a lot of questions. In general, it takes like 2 to 3 hours. They will ask you a lot of questions and they will try to understand the situation. And if you have multiple members in your application, they are going to ask questions to all of them. In the middle of the interview, so at the time of interview, you can take a interpreter with you. You can take an attorney with you. However, none of those are mandatory. You can go by yourself if you like. But if you want to take an attorney, you can take an attorney with you. You can, if you want to take a interpreter, you can take with you. And this interview is usually it's a friendly kind of interview. It's not very adversarial. They're not trying to say anything bad about your application or anything. So yeah, you can go by yourself. There's no problem with that. Once the interview is done, USCIS officer will do three things. Either they will approve your application, or they will deny your application, or they can say, I cannot make any decision. I am referring this case to the court. So if your application is approved, great. You can apply for green card after 1 year. There's no problem with that. If your application is denied, you can go to court, or if the USCIS officer refers your case to the court, then it will go to court. That's where the defensive application starts. However, as I said before, if you entered America through southern border without any valid visa, or you entered America with a valid visa, but later your application, your visa was expired, then you go to defensive asylum. Either way, when it goes to defensive asylum, there is usually two steps. The first one is called master hearing. So master hearing is a kind of very basic hearing process. Judges try to understand in what ground you're applying, which country you're from, what language you speak, whether you need an interpreter or not, whether you have an attorney or not. Those are like the, and then they will schedule a master hearing, master calendar hearing, meaning the big interview, individual hearing. Master hearing is in general very short. It takes like a 4 or 5 maximum 10 minutes, not a long time. On the other hand, individual hearing is the main hearing. It takes like 2 to 3 hours. So in the master hearing process, they will schedule your individual hearing, and usually it's like 6 months or 1 year later after the master hearing. The individual hearing is the main hearing. In the individual hearing, a government attorney will be present, prosecutor, and their job is to establish that your case has no merit. This is a very serious kind of job. They take it very seriously, and they try their best to establish that you do not have a good case to get asylum here in the US. And they will ask you a lot of questions about your application. That's why I say that if you do not have a good case, please do not apply for asylum, because even in the affirmative asylum process, asylum officers, they're very well trained. They can get information from you, and then they will establish that you do not have a good case. Similarly, in the individual hearing, the government lawyers, they will try their best to establish that you do not have a good case. So when you apply for asylum, please think about these interviews. You will be grilled by officials about your case. It's not just you're submitting a case and then judge will decide based on that. It's not. They will ask you questions. So after the individual hearing, judge will give result. If your case is approved, great. You'll be able to apply for a green card application after 1 year. However, if judge denies your case, then it goes to appeal. So I'm going to talk appeal later, but there's another thing I must mention here. The folks who come to America crossing the southern border, first they're arrested because you violated the law and you have been arrested. And then sometimes there's a bond hearing, sometimes there is no bond hearing. Recently, I hear a lot of cases, there's no bond hearing, government just released you under someone's supervision. So in the bond hearing, what governments wants to establish that if whether you have a flight risk, meaning you may leave this country, or if you are going to do any harm to the community or something like that, based on that situation, you have to buy bonds. And sometimes it's like a $10,000, $20,000, $30,000. It doesn't mean that you have to pay $10,000 or $20,000. So there's a small amount of money, usually like a $200, $300 or $500. This bond is issued by some companies. There are some company who will issue the bond, and they will pay that money to the government, and you pay the company a small amount of money, $200, $300. However, if you cannot manage a bond company who is going to pay on behalf of you, then either you or someone like your friends or family, they need to pay this $10,000 to the government. And this money is returnable, meaning if you go back to court for master hearing, individual hearing, you'll get back this money. If you do not show up in the court, then government will keep that money because you could not be present in the hearing. Next slide, please. Next slide, please. Yeah. So now it's appeal process. So if your case is denied after individual hearing, we will go to BIA, Board of Immigration Appeals. In BIA, most of the result from lower court, meaning the individual hearing, will be restored, meaning your result will not be reversed. However, if judge did any mistake or there's any new fact or anything, then there may be some reversal. However, in general, it doesn't get any positive result. In general, it's whatever happened in the immigration court, they will keep it. If your result is not favorable in BIA, then it will go to the circuit court. Circuit court is the highest court for immigration matters. In general, the Supreme Court of the United States is on the top of the circuit court. However, in 99.99 case, it will never go to the Supreme Court of the United States, because by the time you reach the circuit court, there's no issue that may be needed to hear in the Supreme Court. So circuit court is the highest court. If your case is approved in the circuit court or BIA, that's great. You're going to get green card. If your case is not approved in circuit court, then your case is gone. You are in the removal proceeding. All it means is government may deport you anytime. However, you are allowed to apply for a new asylum based on a new fact of the situations. So if you can apply for a new asylum application after your circuit court judgment is rendered against you, then you can stay here. Otherwise, they will deport you. So please take it seriously. A lot of time people case is denied in circuit court and they are like, oh, it's been denied in circuit court, I'm going to do something else. Yes, you can apply for asylum again, but you must show a new fact that is relevant for your asylum application. You cannot just claim the old things and apply for asylum again. Next slide, please. So there are many special circumstances for asylum applications. I'm not going to talk detail because I don't want to make a long presentation today. Today we are only talking about the change of circumstance in your home country. There are many other special circumstances we'll cover another day. So many times it happens. So let's say you are from Bangladesh. I'm giving an example. You're from Bangladesh. When you came to America 1 year ago, the political and other situation of Bangladesh was way different from what it is at this moment. As soon as the political situation gets changed, if your asylum application is not connected with the change in circumstance, then judge may deny your case. Let me make it clear for you. So let's say you're from Bangladesh, you are a member of a political party called BNP. It was an opposition party, and the government was ruled by 𝐈𝐦𝐦𝐦𝐿 party, and then 𝐈𝐦𝐦𝐦 party was very, they were torturing members of the BNP party. You came to America, you applied for asylum as a member of BNP, which is great. your asylum application was pending, and then there was a huge political change in Bangladesh. Now Awami League is not in power anymore. Most of them they fled country. Now BNP leaders, they are not in power, but they're in very favorable position at this moment. So if you still claim that, hey, I'm a member of BNP, government is going to deny your case, because BNP is member of BNP political party is not in trouble at this moment. So you have to amend your application and show that you are still in danger if you go back to your home country. Now, how you do it, it depends on circumstance. I cannot say in advance. It depends on the circumstance. And if you cannot show that you are still in danger if you go back to your home country, you have reasonable fear for your life and liberty, then you have to go back to your home country. Government is going to deport you. So that's a huge thing. A lot of asylum application get denied based on the change of circumstance in their home country. So I'm not going that detail into here. We'll talk about those another day. So that was my presentation today. If any of you have any question about anything, feel free to ask me. We are going to answer all of your questions. Thank you.
Thank you so much, Mr. Mahalan, for this wonderful presentation. I'm sure our viewers will find it very informative and useful. So, there are some questions regarding asylum that we have got in our mail. Let me proceed with that. The first question is how long it takes to get a decision from asylum?
Oh, it's very hard to say that. Some people they get decision within 3 to 4 months. Sometimes some people are waiting for 7, 8, 10 years. It depends on your case, depends on the officer, depends on the circumstance, depends on many factors. It's very hard to predict how long it may take. But yeah, it's very difficult to say.
Okay, thank you so much. So, the next question is can I apply for asylum even if I was convicted of a crime?
Crime here in America or in your home country. In either situation, yes, you can apply for asylum. However, there is a bar for people to get green card if you are convicted of a crime against moral turpitude kind of things. So yes, you can still apply for asylum, and it depends on the judge. Judge may consider it, may not consider it. Sometimes they may not approve your asylum application. However, they can give you CAT. It's a different law. It's called Convention Against Torture. So under CAT, you'll be able to stay here in America. Government will protect you from torture from your home country, but they are not going to approve your asylum and they are not going to give you green card. So there is something in between approval and denial, which is called CAT. So you may get some benefit under CAT, but your case may not get approved.
Okay, thank you so much. So we can see that we have some questions in the comment. 𝐻𝐸𝐿𝐦𝐬𝐿 has some questions for us in different sections. So he's saying that, hi, I wanted to ask that if I have a B1, B2 visit visa approved before, which is valid for 5 years, and then submit my I-140 petition for EB2 NIW green card from outside USA. There is another part to this question. And if my I-140 petition gets approved also, then can I enter the USA when my priority date becomes current with my still valid visit visa and do the process of adjustment of status has valid? I guess that's what he is trying to say. And okay, so let's proceed with the
Yeah.
answer. And yeah.
So the short answer is yes. If you have an approved I-140, and if you have a valid visa, visit visa or student visa or any kind of visa, yes, you can come to America legally, and then you can apply for adjustment of status, no problem. But I think in your text you mentioned that you received B1, B2 5 years ago. So B1, B2 is basically for 5 years. To please make sure before buying ticket whether you have a valid visa or not. If you have valid visa, yes, there's no problem. You can apply for you can come to America and apply for adjustment of status when your priority date is current.
Okay. So another part of Mr. Ijaz's question is, and do I have to still wait for 3 months to do this, or can I do it instantly?
Yes, you have to wait 3 months. Anytime you enter America with a non-immigrant visa, any kind of non-immigrant visa, and then if you want to apply for an immigrant visa, meaning you want to apply for a green card, you must wait 3 months. and then after the 90 days, you apply for I-485 adjustment of status.
Okay. Thank you so much for the answer, Mr. Mahajan. I'm sure that Mr. Ejaz has got the answer that he was looking for. So let us get back to the questions from the email. I have last one question from the email that what if an asylum seeking prospective client asked that what if I need to travel after I have applied for asylum?
It's very difficult. Theoretically, yes, possible. You can travel anywhere in the world, even you can go back to your home country, but we highly recommend you not to travel while your asylum application is pending, especially not your home country. You can go to other country, but in either situation, you have to apply for a travel document. After receiving the travel document approved, only then you can travel, but try your best not to go to your home country.
Okay, Mr. Mahajan. So thank you so much. Now I have some question from our Dhaka branch, which is from some other prospective clients. So the first one is from Sumaya Afrin. Her query is: I am a Bangladeshi citizen residing in Cairo, Egypt, on a visit visa status. I completed my O levels and A levels in Egypt. Can I apply for a student visa from Egypt, or should I return to Bangladesh to attend the consular interview there?
No, you can apply for US student visa or visit visa from anywhere in the world. You do not have to go to your home country. Since you are living in Cairo, Egypt, you can apply for US visa in US Embassy in Cairo, and they will schedule your interview over there, and they will, either approve or deny your visa. All they may need to see is whether you have a valid visa for a valid Egyptian visa or not. Sometimes some consulate, some embassy, they want to see that whether you have a valid visa in that home country, in that country or not. But short answer to question, yes, you can take interview in US Embassy Cairo, get it approved, come to America directly. You do not need to go to your home country.
Okay. Thank you so much for the answer. The next question is from Tanmay Ghosh. My brother filed a family petition for me in 2015. Now I want to apply for a visitor visa. Could this cause any issues? Will the visa officer reject my application?
No, it will cause no problem. Visa officer may ask you question about this family-based application. You must answer truthfully. You must tell that, yes, my brother applied for me in 2015. I don't know how long it may take to process that application. When I get chance to go to USA as an immigrant, I will go there. But now I'm trying to go to America to study. After getting visa, after going there, after study, I will come back to my home country and serve my country. You must mention this. This is the very tricky part. This is a legal requirement. When you apply for a student visa or visit visa, it's a non-immigrant visa, meaning your intent is not immigrant intent. Your intent is going back to your home country. So even though your family-based application is pending, you can go to America for a non-immigrant purpose, like a student study purpose or some other purpose. And after completion of that purpose, you're going back to your home country. So the short answer to your question, no problem at all for family-based application. However, if the officer asks you about the family-based application, you must mention that that one is pending. You don't know how long it may take. Right now, we are going to America to study, and after education, you're going back to Bangladesh.
Okay. Thank you so much for the answer. So the next question is from Mr. Sabbir Ahmed. I am a US citizen and my spouse is currently in the USA without documentation. What are the implications for their green card application which I have to submit on her behalf?
Can you please read the question again?
I am a US citizen and my spouse is currently in the USA without documentation. What are the implications for their green card application which I have to submit on her behalf? I think
Yeah, so
he is asking. Yeah,
yeah,
sorry.
I understand. Yeah. So no, it's okay. So so since you're a US citizen, you can definitely apply for your spouse. It's a family-based application, I-130, and then she also needs to submit I-485 for adjustment of status. On the top of that, since she is out of status, undocumented, you must submit a form 601. It's a waiver form. And since you're a US citizen, I am 99% confident that her application will be approved. She will get green card. You just have to submit this waiver form 601. Other than that, everything is as similar like family-based application.
Splendid. Thank you so much for the answer. So the next question is from Bozlul Haq. If I apply for an E2 visa from Bangladesh and attend my interview at the US consulate in Dhaka IVP, and if my visa is denied, then can I transfer the money I deposited in the US bank for the E2 visa back to my bank account in Bangladesh? If so, what is the process?
Yeah, so if your application is denied, you can definitely take your money back to your home country. The process is very similar. So I am assuming that you already set up a business here in America and you have a business account here in America and you deposited money in your business account. And anytime you open a business as a foreign resident, you must appoint a resident agent here in America. The term resident agent. So the resident agent will go to bank and close the bank account, or even without closing bank account, just withdraw the money and send money back to you. It's very easy. All you have to do is you have to send your resident agent to the bank, withdraw the money, and he or she will send the money back to you. It's very easy to do.
Thank you so much. So this is the last question from our prospective clients that Mr. Abdullah Al Mamun wanted to know that uh, I am employed with a government organization in Bangladesh and wish to visit the USA. Can I apply for a US visa without a NOC from my organization?
Yeah, of course, you can definitely apply for US visa. US government doesn't care whether you're a government employee or not. Bangladeshi government may care about it. So probably, I don't know. It's about Bangladeshi law. If Bangladesh has a law that without a NOC from your respective office, you cannot apply for a foreign visa, then you'll be in trouble. But in American government's eyes, everybody is equal. They don't care whether you're a government official or not. However, if you have like a official passport, and they may ask you about your job and what you do in Bangladesh, what kind of job it is, they can ask you about it. But short answer to your question, yes, you can apply for a visa without NOC.
Okay. Thank you so much, Mr. Mahajan. And with that question, our Q&A session ends. And thank you, everyone, including Mr. Mahajan, for participating in this session. And thank you for your valuable time.
No problem. And dear audience, now we are going to a weekly news update from our team.
So before we wrap up, as Mr. Mahajan said, we would like to give a quick glance on the major immigration news of this week by presenting Weekly Immigration News Update by Rajula. Thank you so much, everyone.
Welcome to the latest episode of Weekly Immigration News by Rajula. This week we brought to you 4 latest developments in the immigration arena. Let's start with the headlines. USCIS launches online PDF filing option. Protections for Lebanese nationals currently in the USA. Lawsuit seeks to block H2A final rule. Removal flights to the People's Republic of China. Let's get into details. USCIS now offers an online filing option for Form I-765 Employment Authorization and I-912 fee waiver requests. Eligible applicants can upload and submit these forms through their USCIS online account, streamlining the process and reducing the need for paper submissions. The update aims to speed up processing times and improve accessibility, particularly for low-income applicants. Paper submissions are still accepted for those who prefer traditional methods. Next up, the U.S. Department of Homeland Security has introduced temporary immigration protections for eligible Lebanese nationals, including deferred enforced departure and a new temporary protected status designation for 18 months due to the conflict in Lebanon. Lebanese nationals residing in the U.S. since October 16, 2024 can apply for TPS, while those arriving after the date are ineligible. Eligible individuals under DED can apply for employment authorization documents valid until January 25, 2026. Additionally, F1 students from Lebanon may request work authorization while studying. More details will be available in the Federal Register notice. Moving on, a coalition of farm and business groups, along with the state of Mississippi, has sued the U.S. Department of Labor to block a rule expanding labor rights for H-2A workers. Filed in the U.S. District Court of Southern Mississippi, the lawsuit argues that the rule is unlawful. Plaintiffs include the International Fresh Produce Association, the American Farm Bureau Federation, and Mississippi. The rule, designed to enhance protections for H-2A workers, are already being delayed by a court injunction affecting several states. Finally, on October 15, 2023, the U.S. Department of Homeland Security conducted its second removal flight for Chinese nationals to the People's Republic of China. This follows a similar flight in June, the first since 2018, signaling renewed cooperation with China on irregular migration. DHS has increased removals in fiscal year 2024 and aims to expand removal flights further. Secretary Alexandria Mayorkas urged migrants not to trust smugglers, highlighting the consequences of illegal entry. Since a June proclamation, Border Patrol encounters have dropped by over 55%.
Asylum status is a form of humanitarian protection offered by the United States. Eligibility of asylum application. Every year, thousands of people come to the United States from different regions of the world seeking protection from persecution. According to the US law, one can apply for asylum if they have suffered persecution or fear that they will suffer persecution due to race, religion, nationality, membership in a particular social group, political opinion. Procedure of asylum application. You can file an asylum application if you are physically present in the United States and you are not a U.S. citizen. There are two types of asylum application: affirmative and defensive. A non-citizen who is not currently in removal proceedings may apply for affirmative asylum through the USCIS. On the other hand, a person who is in removal proceedings may apply for asylum defensively by filing the application with an immigration court. From November 2022, affirmative applicants can file their asylum applications online. Asylum applicants can legally work in the U.S. while their application for asylum is still pending. Asylum applicants now can apply for employment authorization document online. Wherever the asylum seeker stays in the USA, Rajulo provides fast and accurate services with proper care. Rajulo, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.